SJC-12029, Douglas G. Bailey, v. Astra Tech, Inc.
Mr. Houlihan, good morning.
Good morning, Mr. Chief Justice, honorable members of this court. May it please the court, I'm here this morning with my colleague Scott McGee, and it's our privilege to represent Douglas Bailey in his capacity as the shareholders agent for the company's security holders of Atlantis, Inc. In this case, Astra Tech attempts to impose Chapter 93A liability on the shareholders agent and through him on the company's security holders, even though they did not participate in and had no knowledge of.
But aren't all of those people responsible under Section 8B of the merger agreement to indemnify if Atlantis is liable for any of this stuff?
Well, there are several problems with that theory, Your Honor. First of all, I would argue that the indemnification language in the merger agreement does not encompass 93A damages. But even if you interpreted that language broadly to encompass 93A damages, it doesn't help Astra Tech in this case for two reasons. First of all, they didn't plead their 93A claim as an indemnity claim. They pled it as a direct claim based on the actions.
Against whom?
Against the shareholders agent. Second of all, even if they were permitted at this very, very late stage to amend their pleadings to assert an indirect indemnity claim, that claim would necessarily fail because they did not reference Chapter 93A in either their notice of indemnification or their demand for payment, both of which were required under the merger agreement. And those two defects would be fatal to a theory that they were entitled to 93A damages as a matter of indemnification. So for all three of those reasons, Astra Tech can't recover 93A damages as a matter of indemnity. It has to assert its claim based on the direct actions of the shareholders agent.
Now, pragmatically, are you saying that we should be deciding that issue or simply that we should remand to the trial court judge and say it's up to you to decide whether to impose damages under 93A?
That depends on the reason that the court concludes that 93A damages are not appropriate in this case. If the court concluded that 93A damages...
What if the court didn't conclude one way or the other, but just simply said, hey, it got dismissed, it's got to go back?
If the court I think the court would need to articulate why the case was dismissed. So, for example, if what Your Honor is saying is that you say Judge Hinkle got it right.
No, right. I'm saying Judge Hinkle got it wrong, but whether there is liability or not, or can be liability or not, it's never been adjudicated below.
I'm having a hard time understanding how the court could get to that particular conclusion, except on the theory that there was a denial of due process rights in what the Court of Appeals did. Both the trial court and the appeals court found that the shareholders agent was a creature of contract and didn't come into existence until after the merger agreement was signed and the closing occurred. That was the reason why the shareholders agent's claim against the law firm, Foley and Lardner, was rejected because the shareholders agent didn't exist, and therefore there was no attorney-client relationship.
Right.
Well, if the shareholders agent didn't exist,
but wasn't Mr. Stockard also a shareholder?
Yes. Yes, he was. But as Judge Hinkle pointed out Mr. Stockard wore many hats. And the fact that as a corporate officer of Atlantis, he had an obligation to disclose an omitted material fact doesn't mean that as a shareholder's agent, he had that same duty. And,
Well-
the point, I think, Your Honor, is that as shareholder's agent, he didn't have that capacity at the time that he committed the wrongful acts. So if he wasn't the shareholder's agent and couldn't have been prior to closing, how can it be that the shareholder's agent is liable for his wrongful acts that occurred, all of which occurred prior to closing?
Well, I guess I had thought that this would come under the indemnity agreement. Now, I don't, what is the provision that says you have to, that AstraTech had to give specific notice that it was making a claim under the indemnification agreement or merger agreement, whichever it is, well, the indemnification, that 93A damages were being sought?
Mr. McGee tells me it's section 8.2D, Your Honor.
8.2D, okay.
I believe that argument is referenced in our briefing materials. I'd like to go back, if I could, very briefly, to the point that both the trial court and the Court of Appeals found that the shareholder's agent didn't exist at the time that the alleged wrongful acts of Mr. Stockard occurred. As a matter of common sense, the shareholder's agent then could not have participated in those wrongful acts. Mr. Stockard did, but not in his capacity as shareholder's agent.
Okay, I get that. What I'm struggling with is it your view that the only decision before us is to decide whether Judge Hinkle was correct in dismissing it? And if the answer is, well, yes, if the answer is yes, then of course you win. If the answer is no, then the appeals court was correct that all that the trial judge needed to do is to determine whether it's double or treble damages.
No, Your Honor. If obviously, if the court determines that Judge Hinkle was correct, then the matter is
closed.
Is
right.
closed. Even if Judge Hinkle's analysis of the case, even if the court does not accept Judge Hinkle's analysis of the case, the court could still determine, for several reasons, that the appellate court, the appeals court, was wrong in ordering multiple damages in this case. I've already indicated one of those reasons. I'd like to talk about a second one. That is that this court's...
Before you get there, are you saying it wasn't wrong in assuming single damage liability, or you don't clearly care because the damages that were awarded are what AstraTech would get under single damage liability anyway?
Precisely, Your Honor. In that instance, it doesn't matter. But this court has been very clear in its decisions that in order to award multiple damages, there has to be more than wrongful conduct. There has to be wrongful conduct by a wrongful actor. That person has to participate in the wrongdoing. In the Kinsalis case, multiple damages can only be awarded against those defendants with a higher degree of culpability. None of the people involved in this case, not Mr. Bailey, not any of the security holders, didn't participate. They had no knowledge of, there's no evidence they had any knowledge of, the underlying wrongful conduct. So how can they possibly have the kind of higher degree of culpability that this court has required for multiple damages? They can't. They can't. And in this regard, AstraTech fundamentally mischaracterizes the purpose of Chapter 93A. And Chapter 93A is not intended, as AstraTech suggests, simply to punish fraud. It's intended to punish wrongdoers who commit fraud. So in this case, AstraTech might well have had a 93A claim against Mr. Stockard if it had chosen to pursue it. Instead, they chose to settle with Mr. Stockard. But just because they might have a 93A claim against...
They might, of course, have a 93A claim against the company.
They're the successor to the company. They purchased the company, so
that's why the
I
shareholder.
suppose...
Well, I guess I still mean under the if you're right, that they needed to give notice, but it would seem to me, assuming the notice were not an issue, certainly, would you argue that this doesn't fit within 8.2B?
Yes, Your Honor. I would argue that 93A damages are not within the defined capital D damages, that the indemnity provision was,
Pretty broad provision.
it is, Your Honor. It is, Your Honor. But I would go back to the 2 points that I made earlier. Astra Tech didn't plead it that way. They pled it as a direct claim based on the conduct of the shareholder's agent. And they should be bound by that pleading.
I'm afraid your time is up, but, so we'll rely upon your briefs. Thank you.
Thank you, Your Honor.
Mr. Batchelder?
Good morning, Mr. Chief Justice, honorable members of this court. May it please the court. My name is Richard Batchelder. I'm here with my colleague Jennifer Pantina, and we represent Astra Tech. Let me get right to the point. Justice Brodsford mentioned 8.2B, indemnification by shareholders of the company. And we are indemnified for any damages, statutory damages or any damages of any stripe, arising out of or directly or indirectly relating to any fraud or intentional misrepresentation of any of the company security holders or the company.
Yes, but what about the notice question?
Well, the notice question is easily answered. You could look at the, first of all, this isn't a case where we have a demand requirement that is otherwise existing under 93A because it's a business-to-business context. So you don't have that. All we have is the notice of indemnification requirement in the agreement. We sent them a lengthy, multi-page notice of indemnification
You
that
mentioned
specific.
93A?
Did not mention 93A because we don't need to mention 93A. Just like you wouldn't need to, at the notice stage, mention every single cause of action that you might have. It did say, though, that we are seeking damages arising out of or directly or indirectly relating to fraud. And what is 93, after all, but damages arising out of or indirectly relating to fraud? So we put it right in the notice letter. They were on notice of it. This argument that they're making today, by the way, this case has been going on for 9 years. We've never heard this argument before. It wasn't before Judge Hinkle. That's not why Judge Hinkle dismissed this. It wasn't before the appeals court. This is now an 11th hour, let's see what other argument we can come up with because the appeals court reasoning is pretty sound. And when you look at that appeals court reasoning, he mentions that we don't need, that we need to have 93 mentioned in the contract itself in order to recover a statutory remedy. But the Hill case, the appeals court case in Hill, resolved that issue. And in that case, they found 93 liability, even though the contract in that case did not mention 93.
Let me ask you this. Do you agree with the appeals court that as far as single damages go under 93A, you've gotten everything you would ever be entitled to? Including attorney's fees?
No, the way I would look at it, Your Honor, is we're entitled under Chapter 93A to multiple damages
No,
because of the
I'm
willfulness.
asking, that's not what I asked.
Right. And we're not seeking our attorney's fees under 93A. We're seeking our damages under 93A.
Right.
And the fact that our damages happen to be attorney's fees doesn't make them attorney's fees under 93A.
No,
And that's an
I
important distinction.
understand that. What I'm asking you is, do you agree with the appeals court that if the only issue were single 93A damages, you've got them?
We've got most of them. We haven't yet recovered our attorney's fees in connection with the appellate petition, which has been stayed by the appeals court. But for most of the attorney's fees, you're correct. And that's why this is a very important case in terms of precedent. It has to be the law in Massachusetts that if you commit fraud in the sale of a business by willfully, as Judge Fabricant found, willfully failing to disclose a material letter a couple of weeks before signing and closing, that there are consequences. And when you have an agreement which has a very broad indemnification provision, which includes in it as damages reasonable attorney's fees, and then you have a party that sues, and we were on the defensive for 8 years, having to spend millions of dollars in attorney's fees,
All of which you've recovered.
but that's where 93A comes in. 93A has to have some significance here.
But let me ask you this question. The cases that the appeals court cites in terms of the fact that it's okay to remand and just, so that the only question before the trial judge is double or treble, are cases in which 93A was pled, it was before the court, the judge, the trial judge in both of those cases didn't find 93A violation, and the appellate court said, yes, there is, but it was actually in play at trial. This wasn't because of Judge Hinkle's ruling.
I respectfully disagree. If you look at the Datacom case, SJC decision, you look at that case, the master in that case, who did all the findings of liability, did so at a point in time where there was no 93A claim pled. All right? The 93A claim came about in that case after one of the parties read the master's findings and said, well, that looks like a 93A violation. Goes to the judge and says, can I amend and add a 93A? And the judge says, okay, you can amend. But at the time the findings were made, no 93A.
All
And
right,
here
but
our
it's-
case is stronger, because at the time our findings were made, we had pled the 93A claim. They were on notice of a 93A claim,
Well, it had
and
been
the trial was
dismissed.
on
It
fraud.
had been dismissed at the time that the findings were made.
Absolutely it had been dismissed, but the facts and all the evidence, which is contained in a 15,000-page record here, all those facts, all that evidence goes exactly to the 93A claim. This is not a case where, you know, there's some set of facts that go to 93A and some set of facts go to fraud, and Mr. Bailey wasn't on notice that he had to defend vigorously the fraud claim. He did, and he submitted every evidence, every piece of evidence that he thought was relevant to defeating the fraud claim. It's that exact same evidence that would have gone to the 93A claim. So it would be a complete waste to go back to the Superior Court and say, you need to have a new trial on 93A, because we're also entitled to issue preclusion. And there's the case right on that involving the 93A, and I think that's instructive here. If you look at,
Issue preclusion where the case is still on appeal?
so if you look at the Bellarmine case, this is a case where there were administrative findings in one case,
I mean,
and then in a
the
subsequent
DPU
case,
The Bellarmine, the people in Upper Worcester County, yeah.
yes. So in that case, what happened was the court said that findings that were made in an administrative proceedings could be used for preclusive effect in a subsequent proceeding. So obviously, if it can happen in a separate proceeding, it should be able to happen in the same proceeding. This court, the appeals court, looking at that voluminous record, looking at what Judge Fabricant found, the unbelievable deceit that went on here. Imagine again the facts here. We were told about one letter, and then they get the second letter, and they don't tell us about the second letter because they knew that if they told us about the second letter, there goes the deal. There goes the $1 million payday. And when we hear from my brother in his brief that there's all these innocent shareholders, and then they put in parentheses, apart from Stockard, well, Stockard, they have to take responsibility for Stockard. That's why we have a merger agreement that says they're jointly and severally liable. This idea of innocent shareholder has come up time and time again in this case. Judge Fabricant rejected it. Judge Billings rejected it. Judge Kaplan rejected it. This case has gone on so long, we've had multiple judges involved in this case below.
So don't you need to have a new trial as to the setting of multiple damages, if nothing else?
I don't think we need to have a trial on that, Your Honor. I think we could submit the record on that, or frankly, this court could look at that record. Look at the case.
Decide it whether to double or treble?
I don't think there would be.
That's not an appellate function, is it?
Well, if you look at the Schwartz case, for example, which I think is a very important case for this court to look at, look at what Chief Justice Leokas wrote in that case. That case involved a situation where someone was buying property, And the seller of the property, right before 3 months before the closing, found out that there were going to need to be environmental approvals necessary for the buyer to build. And they had a letter from the Conservation Commission to that effect. And what did the seller do in that case? He didn't disclose the letter. So the buyer went ahead and bought the property, and then lo and behold, he couldn't build on it. And so that case, this court said, treble damages. And it's got to be the case that when you have a situation like this, sophisticated party, $71 million transaction, and one party purposefully, through the CEO himself's actions, defrauds the buyer of that business, that there are consequences. That's why we have 93A. And if the result were otherwise, what this court would be saying to parties in Massachusetts is if you're going to buy a business in Massachusetts, you better be very much on the caveat emptor side of it, because you don't know what you're getting, right? And that can't be the law in Massachusetts. This is a commonwealth that has always stood for fairness and not unscrupulous behavior. That's why 93A was enacted.
But if 93A wasn't tried, and the trial that took place in front of Judge Fabricant, she did not allow in evidence that would have, from your opponent's position, have refuted willfulness, why isn't there a remand that's required?
Mr. Chief Justice, I see my time is up. May I
You may
respond?
answer. You may answer.
If you look at our brief and you look at the record, every single piece of evidence that he now says he would put in a trial on 93A, he was given the opportunity to put in, and many of that he did put in. In fact, there's a wonderful quote from Judge Fabricant, and I remember this distinctly. She told us when we had all these depositions, she said, just submit anything you want. And so on that record, where you would submit anything you want, and the case is being tried on a fraud claim, to then argue, well, I should have a do-over because the other claim is called 93A, that would be a complete waste of judicial resources and further lengthen this already very lengthy saga.
A prudential question. If you prevail, unless you persuade us that we should simply award treble damages on your behalf, the case will still go back to now Chief Justice Fabricant. Why should we limit the scope and say, we the appellate court, impose upon you a finding of willfulness, and we now narrow the scope of your decision-making to determine simply whether it's double or treble, as opposed to saying, we send it back to you to consider the issue of 93A, and you can determine whether or not the trial evidence is adequate, or whether you want to provide opportunity for additional evidence to be offered, and we leave it to you, the wise trial judge who knows this case better than we do, to resolve that issue.
Two responses, Your Honor. First, it wouldn't go back to Chief Justice Fabricant because she had to recuse herself at some point well after the trial in this case. So it would have to go to another justice. But more fundamentally, with regard to your question, we have a finding by Judge Fabricant of intentional fraud. It would seem to me that if you have a finding of intentional fraud, which is what the appeals court said in its decision, to send it back and say, is intentional fraud willful or misleading? It's by definition willful or misleading. So there would be
Willful or knowing.
absolutely no point in sending it back for them to rubber stamp the prior finding.
Okay, thank you.
Thank you.